Are defamation laws keeping up with the internet era? Welcome back to How to Legal. In today's episode we'll learn about some of the judges who have been advancing the argument that today's defamation laws may not be keeping up in this internet era of fake news, misinformation and defamation. This topic has been in the spotlight because of Sarah Palin v. New York Times. The case is on appeal. You can go to the article in the description box below to access all the court and trial documents. As always, following court cases is an excellent way to learn about the justice system, freedom of speech, the First Amendment and defamation laws. Okay, let's do this. Among the justices voicing concerns that defamation laws are not keeping up with the times, is Supreme Court Justice Neil Gorsuch. Justice Gorsuch moved this subject forward in the case, Shkels and Berisha vs. Guy Lawson, et al. In this case, Shkels and Berisha is the plaintiff. Guy Lawson is the defendant. Following is a brief summary of this case. In 2015, Guy Lawson published a book detailing the true story of how 3 Miami youngsters became international arms dealers. A central plot point involves the protagonist's travels to Albania and subsequent run-ins with the Albanian mafia, a key figure of which, the book claims, is petitioner Shkels and Berisha. The book performed well, and Lawson eventually sold the movie rights to Warner Brothers, which made the feature film War Dogs. Unhappy with his portrayal, Berisha sued Lawson for defamation under Florida law. According to Berisha, he is not associated with the Albanian mafia, or any dangerous group. And Lawson recklessly relied on flimsy sources to contend that he was. Source: Shkels and Berisha v. Guy Lawson et al. Justice Gorsuch wrote in part. In New York Times Company v. Sullivan, this court declared that public officials could no longer recover for defamation as everyone had for centuries. Now, public officials could prevail only by showing that an injurious falsehood was published with actual malice. 3 years later, the court extended its actual malice standard from public officials in government to public figures outside government, see Generally Curtis Publishing Company v. Butts. Later still, the court cast the net even wider, applying its new standard to those who have achieved pervasive fame or notoriety, and those limited public figures who voluntarily inject themselves or are drawn into a particular public controversy. Source: Gertz. The court viewed these innovations overturning 200 years of libel law as necessary to implement the First Amendment interest in uninhibited, robust, and wide-open debate on public issues, Dun & Bradstreet Incorporated v. Green Moss Builders Incorporated, 1985, White, J., concurring in judgment. Since 1964, however, our nation's media landscape has shifted in ways few could have foreseen. Back then, building printing presses and amassing newspaper distribution networks demanded significant investment and expertise. See Logan, Rescuing Our Democracy by Rethinking New York Times Company v. Sullivan, 2020, Logan. Broadcasting required licenses for limited airwaves and access to highly specialized equipment. Comparatively large companies dominated the press, often employing legions of investigative reporters, editors, and fact-checkers, liberty for all or privilege for a few. And thanks to revolutions in technology, today virtually anyone in this country can publish virtually anything for immediate consumption virtually anywhere in the world. Logan, noting there are 4 billion active social media users worldwide. The bottom line? It seems that publishing without investigation, fact-checking, or editing has become the optimal legal strategy. Under the actual malice regime as it has evolved, ignorance is bliss. Combine this legal incentive with the business incentives fostered by our new media world, and the deck seems stacked against those with traditional, and expensive, journalistic standards. And in favor of those who can disseminate the most sensational information as efficiently as possible without any particular concern for truth. Source: Supreme Court Justice Neil Gorsuch, Shkels and Berisha vs. Guy Lawson, et al. As Protocol reported, Supreme Court Justice Gorsuch was not alone in his opinion about defamation laws. Gorsuch's conservative colleague, Clarence Thomas, who has suggested treating social media as utilities bound to carry all political speech, and ending tech's prized legal shield, cited Pizzagate in his own writing on why he would have taken the case. The tech's prized legal shield Justice Thomas was referring to is Section 230 of the Communications Decency Act. For over 2 decades, plaintiffs, lawyers, and judges have warned about the dangers of a misused and abused Section 230, and how it's harming innocent people to no avail. See for example, Ryan J.P. Dyer, The Communication Decency Act Gone Wild, a case for renewing the presumption against preemption. But that's a how to legal for another day. Since that time, Justice Thomas has been caught up in controversy questioning his integrity. It was revealed his wife, Ginny, urged then-President Trump's chief of staff to pursue unrelenting efforts to overturn the 2020 presidential elections. In brief, the Democrats are calling for his recusal in any January 6 cases, while others are demanding that Justice Thomas should be impeached. Time will tell what happens to Justice Thomas and his role at the Supreme Court, if anything. On the appeals level, Judge Lawrence Silberman of the District of Columbia Circuit has also questioned the landmark case, New York Times Company v. Sullivan, and how it shaped defamation laws with the current times. In a blistering dissent, essentially directed at the liberal media, Judge Silberman wrote, in Todd and McLean vs. Global Witness Publishing Incorporated, in part, "It should be borne in mind that the first step taken by any potential authoritarian or dictatorial regime is to gain control of communications, particularly the delivery of news. It is fair to conclude, therefore, that one-party control of the press and media is a threat to a viable democracy. It may even give rise to countervailing extremism. The First Amendment guarantees a free press to foster a vibrant trade in ideas. But a biased press can distort the marketplace. And when the media has proven its willingness, if not eagerness, to so distort, it is a profound mistake to stand by unjustified legal rules that serve only to enhance the press power." Source: Todd and McLean vs. Global Witness Publishing Incorporated. Eric Wemple of The Washington Post weighed in. He pointed out how this topic goes both ways. My question for Judge Silberman: does he believe that New York Times vs. Sullivan somehow doesn't protect Fox News, New York Post, Wall Street Journal? I would argue that those outlets, particularly Fox, lean more heavily on the New York Times protections than any other. Dissents? What do you think? Do you think defamation laws are keeping up with the internet era of defamation, fake news and misinformation? Please comment in the comments section. Let's wrap this up. Thank you for stopping by How to Legal. To access all the court cases, full citations and sourcing referred to in this episode, please click the link to the article in the description box. Please comment, share, like and subscribe, so more people can learn about freedom of speech and the United States justice system. Thanks for watching.